paragraph 24 is trying to imply that IROD's role in routing communications was part of some broader retaliatory or obstructive conduct. Based on what you've described, that framing is legally thin. Let's unpack it. Number 1. Ongoing harassment described in this complaint. That phrase is doing a lot of work without specifics. A court will ask, what specific harassment? By whom? On what dates? What statute was violated? What criminal elements were met? If earlier counts rely primarily on public filming, online speech, reciprocal live stream commentary, lawful firearm possession, then labeling it harassment does not make it legally actionable. Conclusory repetition does not substitute for factual specificity. Number 2. Routing communications through county counsel. Once Frederickson gave notice of intent to sue, then filed suit, the county was entitled, and in fact required, to route communications through legal counsel. That is standard litigation protocol. When litigation is pending, employees are typically instructed not to engage directly. Counsel becomes the point of contact. Communications go through the attorney. That is not retaliation. That is litigation control and risk management. Number 3, official capacity role. If AROD was appointed as counsel for the county officials, possibly employees named in the suit, then his actions were in an official representative capacity. For liability to attach, there would need to be personal misconduct outside the attorney role, independent constitutional violation, actions beyond representation. Merely serving as conduit for communications is not actionable. Number 4, protection order context. If Frederickson sought protection order relief and the county responded through counsel, the court ruled the matter moot, that is judicial disposition, not attorney misconduct. Attorneys advocate positions, judges decide. The denial being moot strongly suggests procedural grounds, not interference. Number 5, structural legal barriers. For count 4 to survive, he must show AROD personally violated a constitutional right. He must overcome absolute or qualified immunity. He must show something beyond routine litigation representation. Routine legal defense of the county is protected. Number 6, the core problem, paragraph 24 essentially says, I sued the county. The county responded through its lawyer. That is not a constitutional violation. That is how litigation works. Bottom line, if the facts are as you've described, the harassment allegations are legally weak. Communications were routed through counsel after notice and filing. AROD acted in official capacity. Court decisions were judicial acts. Then count 4, as framed, lacks a clear constitutional hook. If you want, I can now evaluate whether AROD would likely have absolute immunity, qualified immunity, or dismissal based on lack of personal participation.